Okay. We're not going to begin the seminar on ethics and the real estate assessment issue and crisis facing Allegheny County. Pennsylvania is one of the few states where most of the revenue for the school districts comes from a tax on the value of your land. Which doesn't make a lot of sense. It should be the value of your income, but that's why the value of your land is very important and your buildings. And assessment shows the value of your real estate. And when you buy a property, say for $1 million, there's a presumption that that's exactly what it's worth because it's you bought it in an arm's length transaction. So whatever you paid for it is what it's worth. You can usually reduce it if you can find out that you made a mistake, you found asbestos or something, but that's pretty rare. The only way you can reduce it is by finding out what the common level ratio is, and that'll reduce the market value of your property. And to tell you about the common level ratio, what it is and what the big issue is Michael Suley, who is a real estate consultant to John Silvestri, who is a prominent real estate lawyer in Allegheny County who's brought the common level ratio lawsuit. So here is Mike Suley.
Thanks, Bob. I have a PowerPoint. I hope that we can answer some of the questions about what is the common level ratio and then how it is applied, how it should be applied, and how it wasn't by county assessors. So I'm going to run through my PowerPoint here. All right, I'm going to start it where we were a month ago. Common Police Court Judge Alan Hertzberg in the Joffrey case. It's pronounced Joffrey. I've met the young couple, the lead plaintiffs, the lawsuit, and this is what the judge said from this evidence. There could be no doubt that Allegheny County's Office of Property Assessment had been, quote, cooking the books on CLR. CLR stands for common level ratio, submitted to the state. STEB is the State Tax Equalization Board. Boy, and it's not moving again, is it?
It is on the screen behind you.
Oh, okay. Then we have the political problem with the county executive's office is responsible for all activity in the assessment office. In other words, the assessors are under the jurisdiction of the county executive. The county executive is also responsible for, sending out getting the tax bills out and the millage rate. And there's that mix there. Do you favor revenue over fair assessments or both? That's the way it should be, right? So this was a quote in the newspaper last year where Mr. Fitzgerald said he believes a reassessment would put Allegheny County at a competitive disadvantage, noting that many of the counties surrounding haven't reassessed in years. Not necessarily, but that's what he said. Since the last court-ordered reassessment, the county, in the county, medium sales prices for houses have increased about 250,000 from 100,000. So here's the county executive acknowledging that property values have gone up. I think most of us know over the last 10 years, property values have gone up. STEB, the State Tax Equalization Board, under state law, you submit data to STEB, and the county assessors are pretty much on the honor system. The way it works, you send information to the state, and the state doesn't really crunch the numbers that much. They're supposed to be crunched here in the county. You have good sales and bad sales. I was a part of the oversight for the 2012 reassessment. It was over 12 years ago, almost 13 years now. We started not at 100% of market value. It was a political decision through the county executive's office that all property values across the county be assessed at 92%. That way, politically, you can keep those appeals cushioned and down. Unbelievable. Then I'm going to run through the common level ratios in some surrounding counties. The first year of a reassessment, everything is assessed at 100%. I'm going to go through each year up to the present. And you can see the first year after the reassessment, we're at 90%. That is because we started at 92%. But we didn't apply 92% in appeals at the time. Everything was assessed on appeal at 100%, but that has changed since. So I'm going through each year, and you can see the progression of where the common level ratio is going. And I want you to just focus on Allegheny County. 2019, 87.5. This year it was certified at 81.1. I talked to John Silvestri, the lead attorney, and Barbara Stern 2 years ago, I think when we started the lawsuit, and we just looked at these numbers and said, property values are going up. If property values are going up, the common level ratio should drop. And we didn't see much fluctuation with the common level ratio. Here's what the judge said on September 1. This is how it's applied in an appeal. If the county appeals board says that the property is worth $100,000, the county appeals board takes a percentage of that, 63.53, which I believe will prevail, and that's your new assessment. That's how that would work. Pretty easy. We're going to discuss this later about appealing a current market value or a base year value. But all I have here is, believe me, if the common level ratio drops, that means property values are going up. I said it's a cash cow. If the county does a terrible job of assessing, I was quoted in the Post-Gazette saying this, we don't assess for 10 years. We essentially have frozen assessments. Some of them, so if you look at a sales price, some of the ratio of the present assessment to the sale price is 40%. It's unbelievable. In closing, I made some recommendations to the county council. I've been working with the county council, and I asked county council in the year 2000 under the new home rule that it was a huge mistake putting the county executive in control of the assessment office. At one time in Allegheny County, the assessment office was independent of the county commissioners. Home rule came in and they said, look, we're going to fix the assessment system. We're going to fix the assessment system and, you know, put all control under the county executive, who is also in charge of the budget, the millage rate. And then we're going to have a separate appeals board, an independent board. And that's another question for another day. But all I'm showing you is the progression over 10 years where the common level ratio didn't move that much. There's only one day this year that was a huge event for taxpayers. September 1, 2022, when Judge Hertzberg said that the work product of the county assessors, after conducting a review of their work, showed a common level ratio of 63.53%. That has been in limbo. There was only one day where other entities honored that number, but it hasn't been applied at the county appeals board. I don't believe it's been accounted for at the Board of Viewers in Common Pleas Court. I've talked to a number of people who are in the middle of negotiations in Common Pleas Court, and they call me and they say they want 70%, they want 80%. And somehow, hopefully, county council and the county executive going in the next year can fix this. And I've talked to thousands of people. I'm getting emails and phone calls. I'm past president of the Realtors Association. And what they're saying is, if I bought a house in 2017, Mike, are they going to fix it? I don't know what the answer is now. Whoever, you know, the only confidence I have is that the courts will fix this. The county really messed it up. The appeal by the Pittsburgh School District. The Pittsburgh School District was excoriated by the judge just last month for filing an appeal to Commonwealth Court. And what they said was the PPS was okay with overcharging taxpayers at this point by filing that appeal. I was around in 2001, the last court-ordered reassessment I was involved with. I was involved with two, and the Pittsburgh Public Schools overcharged taxpayers in 2001. The judge, then Judge Reddick, said basically the same thing, that the Pittsburgh School District was overcharging. He ordered the school district to lower its millage rate and put millions of dollars in escrow to be used the following year. That was the anti-windfall legislation. So we've had this event twice in 22 years, and hopefully this will be resolved. In September, county assessors sent their work product to the State Tax Equalization Board. It's 3 months later, and we haven't heard a word from the state about fixing this. And, you know, state law says that they have to certify people in suits in Harrisburg. We're waiting for 2 or 3 people in suits to certify these new numbers, and they haven't. It's ridiculous. Well, all right. You can take that off.
As everybody knows, when there's a lawsuit, there's 2 sides to every story. And the good news about this is the seminar is we have the attorneys for one side and the attorneys for the other side. Before we introduce the attorney for the school district, John Silvestri, the lawyer that filed the lawsuit, is here. And John, you have some ethical issues that you want to share with us. How about just coming up right now and sharing them? And then we'll let the school district respond. Well, you talk about what you have there.
Good afternoon. What I realized when Judge Hertzberg had made a decision, and Judge Hertzberg really didn't make the decision, it was Allegheny County. Allegheny County did a recount of what it sent to the State Tax Equalization Board. And after it did the recount numbers, if you apply the formula for the common level ratio, tell us that it's 63.5%. This is not Judge Hertzberg's number, although he put it in an order. This is Allegheny County's number to which you apply the formula that the State Tax Equalization Board applies. So after we have this, and Judge Hertzberg wrote in his opinion that, quote, Allegheny County was cooking the books, end quote, which Allegheny County admitted because they agreed to the recount, and the recount produced what it produced. I began scratching my head because some school solicitors, when I would go to Board of Viewers conciliations, would continue to want to push the 81.1%, or if it was an older case, the 87.5%. And that has clearly been admitted by the county as a wrong number. And what I would say is this: when I was the Board of Assessment Assistant Solicitor, I did legal research on how these cases are supposed to go. And the first 2 items in the cases, and we did this before we had the Board of Viewers, is you offered into evidence the assessed value. The next item you offered into evidence, and this was done by the county solicitor, was the common level ratio. And what was bothersome to me is solicitors were pushing what we know is the wrong evidence of common level ratio, which is the 81.1%. And so I started reading about ethics, because we're not supposed to be deceptive to the opposing party. And I didn't find under the opposing party ethical rules, but what I did find was Rule 3.3, candor to the tribunal. And when I presented to school solicitors who acknowledged that the 81.1 is a wrong number, and I say, do you have evidence that 81.1 is correct? Did you do anything independent? And I get an answer, no. I point out that A lawyer shall not knowingly offer evidence that the lawyer knows to be false. And then it goes on. And the 81.1 is clearly false. That's the ethical item that I've been addressing. And I have been getting some success in some solicitors recognizing that the ethical obligation trumps their obligation to the client to raise money. That's all I have to say. Thanks.
That's an excellent point. This is a lawsuit where the taxpayer is brought, represented by John Silvestri, against Allegheny County and the Allegheny County Assessment Board. And I get the impression that the county does not necessarily disagree with the judge's finding, but the Pittsburgh School District entered their appearance, and they have one of the finest and ablest lawyers in Allegheny County, and they've raised some interesting defenses. And here to discuss their defense is Megan Turnbull, representing the Pittsburgh School District.
Well, good afternoon, and thank you so much for allowing me to join you in the room and remotely today. My name is Megan Turnbull. I'm one of the partners at Weisberg Hart Kramer. We're a law firm that represents exclusively school districts and municipalities. We are solicitors. We are not solicitor for Allegheny County. And so when we're talking about this Geoffrey case, I think the important thing to know is that Pittsburgh Public is not a named party, at least initially on the complaint. That was an action initiated by taxpayers against Allegheny County. Pittsburgh Public, looking at that and trying to understand the potential impacts of that case, joined as an intervener. And I will say, for the most part, kind of sat to the side. The judge did not particularly address us as a party. And for the most part, as this matter kind of moved towards a hearing, it's interesting because it was the county and the plaintiffs who unilaterally decided that they were going to attempt to negotiate a resolution. And that is kind of the exercise that we've heard Mr. Suley discuss today with the evaluation of sales data. None of that sales data initially was provided to PPS. And so I would say that we were watching and concerned. And there are a whole lot of different ways to view these cases. The litigation at this high level of assessment or down to the micro. There's different equities and interests that are involved. And I guess I then bring a more unique one in the sense that, in the role of the solicitor, I see this playing field as much broader and bigger than any one property. And so when we're talking about the common level ratio and what happens practically if that common level ratio drops? If that number is wrong, then that number is wrong. I think we get there. Now, who has the authority to decide the number? It is not a typical exercise ever in the history of the Commonwealth that I know of, for a judge to decide by order what the common level ratio is. There is a framework within Pennsylvania. The STEB does have the authority to do so, and there's a different forum. So lawyers, we start talking about forums and parties and these laws, and I know that there's a point where, as a lawyer who doesn't necessarily practice in this area all the time, or as a property owner, it all starts sounding like a whole lot of gobbledygook. But in the end, we have impacts. And I think the impacts are where the taxing bodies and where I stand as a solicitor as having some concern. So I'll share some of those with you. And you may still look at PPS or solicitors as the big bad wolf in these matters. But, when the most immediate impacts of when we're talking about this and our concerns, common level ratio, we know definitively it is going to change for next year. It is going to be much lower. It's going to be in the 60s, right? So I have in our office and many other offices have taxpayer initiated appeals. They've been pending since 2000, 2001, and a lot of them are COVID impacts on businesses, on malls, on hotels, on high-rise buildings. This case, what concerns me is when the tax base drops out, not because of an individual residential property owners, but it's when the entire tax base is eroded very quickly without a way to recapture that. Because you know what happens? Government costs, at whatever level it is, government costs what it costs to run government. Schools cost what they cost. Police officers and police departments and public work departments, whether the CLR is X or the CLR is Y, it costs that to run government. And so when we're talking about assessments generally, and CLR plays into this, what an assessment ultimately is, what we're talking about is who pays the fair share of the burden. And so when all of the commercial tax base drops out, for example, we have South Hills Village Mall, it's been under appeal since 2000. If that case rolls over to 2023, guaranteed the new CLR will apply to that. And we're talking about probably in the end, hundreds of $1,000s of refunds to the mall owner. So when all of that erodes, and if people don't want to lay off teachers, what they're gonna have to do is raise the millage rate. And it's going to be those who possibly can least pay the taxes, because the millage rate is uniform, right? It applies to every property owner equally. And so what I hope for, and I think that I heard this shared by Mr. Suley, and probably many who operate in this realm, is that we want a fair system. And it's so difficult to arrive at that by pulling the singular lever of the CLR or one kind of component. It really does take a reassessment. Now we've heard, there are political ingrained reasons for that not happening, but you saw some of those CLR changes. You would have seen Washington County, all of a sudden that number jumped up real high and it's slowly coming back down. That's because they had a reassessment. They had a court-ordered reassessment. Beaver County is about to implement it, I believe, the next year, if not two, a new reassessment that was court-ordered as well. It's, when we talk about Allegheny County Council and hoping that they will fix this for us. Certainly we try to exert control where we have it or where we can find it within a system. But following the Clifton decision, which was when the Pennsylvania Supreme Court invalidated the then base year system with the 2002 base year, as adopted and enacted by Dan Honorato at the time, there was a challenge in Judge Weddick's decision. in the U.S., in the Pennsylvania Supreme Court's decision, and that was to the legislature, our state legislature. Because there's an overarching set of Pennsylvania laws that apply to all counties and everywhere across this Commonwealth to do this right and to do this better. Pennsylvania is now singular as the only state in the entire country that allows an indefinite base year, which is what we have right now. And that's kind of what we're talking about, how things just, bad numbers get crystallized and preserved forever. And then others kind of feel like it's unfair that their neighbors get a free ride. When I used to do more of this work kind of at that ground level, I think I would joke, and it resonated with some people. And it was this idea like, if neighbors could appeal neighbors' assessments to fix them, we'd have this all fixed in about 3 years, because neighbors know exactly what their neighbor's property is worth relative to their own. But that's not legal. That's not how we do it. But is there a way to do this and do this better? There absolutely is. But it really is going to take, some higher level legislation, I think. And then if not, we're just going to do the best that we can in the meantime. To address some of the ethical kind of bombs that were thrown a little bit, a lot of times at the Board of Viewers, that is where many cases go to be resolved if they are not at that initial level, at the BPAR level. Those are very much horse trading exercises and pure conciliations, and often, I would say probably at least 98% of the time, result in stipulated settlements between parties. Now, how they arrive at those parties and the advocacy points that they use in terms of a CLR or fair market value or just the horse traded number to get a resolution, I think that is the exercise. And so I do not believe that there is an ethical violation in engaging in open negotiations. Ultimately, the CLR is applied by the court if a case is litigated before the Board of Viewers or on exceptions to the Court of Common Pleas. And how the court would choose to do that is within their judicial providence, and I would expect that to to be correct. So those are just some reflections that I want to offer. And I'm happy to answer any direct questions or those posed by the moderator.
Okay, I do have a question. Megan, stick around for a minute.
Uh-oh.
Megan gives some excellent points about how this could be remedied. That requires legislation, that requires a change in this crazy process where every county assesses differently. For example, Butler County, as Mike showed you, they assess at 7% of market value. But getting back to the lawsuit, it seems to me that your biggest complaint about the lawsuit is not that the judge is wrong, or not that the county is wrong in saying the common level ratio is 60.3%. I think your biggest problem is that it's going to financially hurt the school districts. And to me, that's not a legal argument. Yes, it's going to cause some financial difficulties. In fact, it may cause catastrophic financial difficulties, but that's beside the point. The point is, if the common level ratio should be at 63%, how can you argue? It seems to me that you're stuck with that decision. And the fact that it's going to economically disadvantage you is not a good legal reason.
No, and that's not I offered that as just kind of some insight into a municipal or a school position. That's not the legal basis for the appeal. The legal basis is that Judge Weddick does not have Judge Hertzberg does not have the legal authority to do what he did. There's no authority for much of what happened, and then there still needs to be considerations on impact. Ultimately now what we are talking about is almost a year out of time what the CLR should have been once upon a time. This should be prospective in nature only. Now, this case itself arises largely under the equitable powers of the court, and I'll say that has very much felt like just like a complete free for all. There have been no rules of civil procedure really in this courtroom. And again, I think there are some hardcore legal concerns back behind all of it. And then separately, and the county isn't here to defend themselves, but there is another position where every municipality and school district in Allegheny County reasonably relied on the valuation and on the county to implement this process that they are legally required to do with fidelity. And there is a point where those impacts then, if there are any, need to be considered, and unless PPS is a party in this or another with similar standing, there's not a way to raise that. So there are in fact deep legal concerns about this, and even about using this tool to force a common level ratio or review. Are we going to do this every year, where a plaintiff's, and I see, and my friend in the back of the room is nodding his head yes, that he intends. But I will say, even in this process, because we're doing this with some candor, there were cherry-picked sales. There were issues and groups of sales out of the data set that were identified by the plaintiffs. The county did not take those rules and then apply it against all sales. So there is, it's a stipulated number. It's stipulated changes to a data set. They were not universal rules that were applied against all sales. And so I do have concerns about the actual validity or the uniformity. In the end, I didn't sign off on a consent order. So, that's for two other parties to say, yeah, we think that this is the right thing. But I stand here and look at each of you and say, that was not a completely function of government the way that it should work, which is, predictable, uniform, open, and fair rules applied in a way that is transparent and can be replicated. And that with a tax system, guys, that's what we need. That is what the Constitution guarantees in terms of uniformity. And when we litigate and we cherry pick and we kind of cordon stuff off, we don't get there. So I do have concerns. They are legal concerns, and they're backed by some thoughtfulness.
Okay, Mike, go ahead.
Yeah, thank you, Megan. There is no appetite for a reassessment in Harrisburg. I talk to state lawmakers all the time. No appetite at all. That isn't going to happen. I've talked to Rich Fitzgerald. This is his last year coming up as county executive. He will never have a reassessment on his watch. The candidates for county executive, I dare any of them to say, I want to be your county executive and I will reassess all the properties in Allegheny County. So let's just put that reassessment issue aside and say, absent a reassessment, we have a reassessment on appeal. Every one of us in Allegheny County have a vested interest in the outcome. Yes, the Pittsburgh Public Schools has an interest in the outcome. I do as a property owner. But I will tell you one thing about, we have to raise the millage rate. All the new construction that we've seen the last 10 years in Allegheny County, billions of dollars of added assessed value. I never saw a drop in the millage rate. That was just gravy to the taxing bodies. Anybody who bought a home in Allegheny County, the last 20 years, Madeline Joffrey, her taxes doubled. No one cares about her budget. In fact, she and her husband said they're going to hold off having children because their taxes double. They pay $9,000 a year in taxes on a $200,000 house in Wilkinsburg. If the county executive, the General Assembly doesn't want to do anything else, we're stuck with this 40-year-old law where you equalize the assessment based on recent sales, arm's length sales. And again, this is the county assessor's work product. That's the law. That's the law. It's only fair that all of us pay our fair share, but we shouldn't pay 1 penny more going into an appeal. And yes, the school districts have a lot of concerns about this, but this has been, as I said earlier, a cash cow to the taxing bodies. They're reassessing people who are buying homes. There's nothing right or fair about that. Property values over a 10-year period, when I was in oversight for the 2001 and the 2012 reassessment, over a 10-year period, 90% of the properties didn't change values. So there was a millage set on those values, and that was certain income. New construction, the appeals process. This past year, 90% of the appeals were filed by the taxing bodies. That's not fair. You shouldn't have to appeal your way to uniformity. But if you're in an appeal, 6353 is a good start. I don't think 63.6 next year is the right value. And John and I have talked about going back to the judge, and it's just like calculating a batting average, to mathematicians. You have to look at the level of assessments to the current sales prices. That is state law. And the work product of county assessors show that it's not 81.1. There's no way that anyone in Harrisburg, that the Commonwealth Court or the Supreme Court is going to say, oh yeah, we're going to tax people at 81.1% because it was certified by the State Tax Equalization Board. We're not in uncharted waters. We're in a period where we have honesty and fairness in taxation. Bob?
I do agree. I think we all agree that Mike and Megan are correct. The politicians, the county executives are not going to order a reassessment. I'm a former county commissioner. We treated the assessment board like it was a leper colony. We went nowhere near it because when they reassess, they raise the market value of many of our homes that haven't been assessed in years, and that means we pay extra school taxes. So the only way it's going to happen is if the school districts get together and file a lawsuit and go to the Supreme Court, which they've done in the past, and the court compels a reassessment. We're going to talk about what we can do next year and how to appeal your assessment, and if you're going to get a refund and how to do it. But before we do that, we're going to discuss some of the ethical considerations that the average homeowner has to consider. Allegheny County, you're allowed to file your own assessment appeal. And now it's by telephone, and you'll be on the telephone with a board member who will say, I swear you in, you swear to tell the truth and nothing but the truth, and then you can talk. David Martin is an attorney in our office. He'll explain how it works and some of the ethical issues, and then we'll get back to how to file an appeal this year and next year and what's going to happen.
Thank you, Bob. Good afternoon, everybody. As Bob stated, my name is Dave Martin. I'm an attorney with Robert Peirce and Associates, primarily specializing in medical malpractice cases, but also assisting Bob with the with property assessments, board of viewer appeals, and things of that nature. As you have all heard over the course of this presentation here this afternoon, is that throughout the idea of uniform taxation and assessment appeals and evidence that may correspond with either increasing or decreasing fair market value or an assessment, those are all things that are fraught with ethical issues, right? And as Bob was stated, it makes sense to have a discussion for, as relates to practical considerations for homeowners and their legal representatives as it relates to that initial stage when there's either an appeal that's brought by a homeowner or an appeal that's brought by the school district or the taxing body to increase the assessed value of the property after a transaction. And as Mike had indicated, as we have multiple parties that are prevalent throughout this, we have the taxing bodies, the schools, the municipalities, the property owners. Everybody has their own unique interests in the case. Okay, if you ask a property owner what their interest is, certainly it's going to be reducing tax liability. Whereas if you ask, potentially a taxing body, their ultimate goal may be to increase tax revenue. But at the end of the day, and as John had mentioned earlier today, there's ethical obligations for both sides. And a lot of the times when you get into the assessment talk, there's attorneys involved. And specifically Pennsylvania Rule of Professional Responsibility 3.3 specifically provides that we're under oath. As a lawyer, we have an ethical duty to express candor towards the tribunal and to ensure to the best of our ability that the evidence that we're presenting or the facts and arguments that we're making are based in fact and actually true. There's a lot of problems that can arise for both legal representatives and homeowners regarding any misrepresentation of facts, misrepresentation of evidence, or falsifying of evidence and facts. And as everybody will tell you, there have been instances in the past where it may result in a perjury charge if you're a property owner appearing on your own behalf, if you're a non-lawyer representative. And then if you're an attorney, certainly those are prevalent as well. But then there's also the added layer of potential disciplinary proceedings with the state board. So it's very important that the attorneys, to the extent that you're represented by a non-lawyer representative, or if you're a property owner appealing your property or defending an increase in the assessed value of your property, that the evidence that you present is true and correct to the best of your knowledge. And certainly, at the end of the day, while there are objective factors that taxing bodies or property owner representatives may utilize in arguing the value of an assessment, such as county data or comparative sales, things of that nature, there's a certain sense of subjectivity in the arguments that you're making. Good faith argument is fine. Again, as long as it's based in fact and it's not intentionally misrepresentative of the true facts of the case. As Bob had indicated, for property owners appearing pro se or for non-lawyer representatives, whenever they call into the hearing, they're sworn in by the hearing officer prior to presentation of evidence or presentation of their case. And that therein subjects you to that penalty of perjury if you're misleading, if you're providing misleading facts to the board. And certainly as it relates to an ethical perspective, for attorneys, it's we all have to be careful that everything again is true and correct, and the facts that we're presenting are such that it's not cooking the books, as they may say, or anything of that nature. So and some examples just to close out here as it relates to the ethical considerations of homeowner appeals, which more than likely than not, we're going to see in the next year or two if the CLR is decreased as many expected to. For instance, if there's material evidence as it relates to income and expense statements for a commercial property that you're not providing to opposing counsel or to the board of viewers or the BPAR hearing officer, that could be intentionally misrepresentative of the true assessment value of the property. As it relates to residential evidence, failing to disclose that you had a significant amount of work done, if you had a new kitchen put in or you had some additional work put on the property, that could also be misrepresentative of the true underlying nature of the property. So it's very important for all parties involved to present the facts and not try to mislead or misrepresent anybody.
Okay. Thank you, David. We're going to go to the question and answer portion of it. I'm going to ask the first question. I bought my property in 2020 and I appealed it, got my hearing 6 months ago, and they reduced it by 83% because that was a common level ratio for this year. Can I appeal it again next year and say, wait a minute, I paid $100,000 for my property, you reduced it to 80,000, but it should be reduced to 60,000 because it's worth the same now as it was 2 years ago. Megan, how would you answer that?
I say yes. I think people have the right in any given year to exercise their appeal rights. There can be, now the practical part is that if there isn't a change in condition, you would not expect necessarily that value would be dramatically different because all of these different methodologies are still trying to arrive at a singular base year value. So the ultimate goal and the standard is the same. It's just how you get there typically can change. So I say yes, and just although not an answer to this question, I wanted just to piggyback one other just brief note on ethics, so I do understand that this is for lawyers and ethics credit is available, and that is to note that there are times where when matters, whether it's initiated by the property owner or the school district or other taxing body, when an appeal is elevated to the board of viewers, that is in the court of common pleas. And so the expectation generally is that all the parties are either represented by an attorney or themselves. It can be problematic for non-lawyer owner representatives to appear on your behalf. So if you are a property owner and trying to consider your options for representation or assistance, be aware that you may receive an objection from a solicitor if they are there. If you don't have a lawyer with you or someone other than a lawyer. That being said, your support person, like another family member, I would never object to that. But someone who is being paid to do that, I really do. I think under the rules of professional responsibility need to be a lawyer in a court setting. And I'll also say that a lot of school districts and taxing bodies, when cases are kind of move their way into the board of viewer level, so on appeal, you may receive all sorts of communications from lawyers, and that could be plaintiff-oriented lawyers who are offering their services. You may also receive a communication from the school district or from one of the taxing bodies inviting a dialogue. So I raise that because as a lawyer, we have separate obligations when we're dealing with unrepresented parties, and it's a place where I feel that our ethical standards should be at the highest in terms of clarity and transparency and openness with the unrepresented party. You have no obligation if you receive such a letter to necessarily engage. And I'll say our office doesn't do that a whole lot, but I know that there are others that do. And there's a point where a lot of property owners just want a value resolved, or they might want to start talking to the lawyer or the representative for the school district. So you're certainly always free to do that. Know that there are ethical rules that govern what, if it's a lawyer on the other side, what that lawyer says to you, and you always have a right. And we will always encourage you to have a matter reviewed or consult with a lawyer if you wish to do so. Otherwise, you can negotiate resolutions singularly with that party.
That's a good point. And you will be getting letters from lawyers soliciting to say, well, I'll appeal it for you. You want to do two things. You want to first find out exactly what their fee is. Most of them are a percentage, but you want to make sure you know what the percentage is. The other thing you might consider next year, there are going to be a lot of appeals. You first appeal to Allegheny County Board of Assessments. Let's say you have a form, you can fill it in. It doesn't cost you a penny. There's no filing fee. You can handle that yourself in a telephone conversation and see what happens. If you win, you don't need a lawyer. If you lose, then you could contact a lawyer. So what about questions? We have questions now?
I don't see any.
Okay, John Silvestri. And we can ask our own questions too.
Go up to John.
I'm going to piggyback on what Megan had to say. And it's the many, many letters that every property owner receives from an attorney who wants to represent them. And in addition to piggybacking on what Megan had to say, I'm also going to say that it's not the school districts or their attorneys who are the subject of criticism, or maybe too much criticism. I'll just give you an example. I get frequent calls over the course of the appeal period from people who said, my neighbor said I should call you, John. I've gotten 3 lawyers giving me 3 letters to represent me, and they're all saying that they can save money for me. What I tell everyone who calls me and asks me that question is, the Board of Assessment rubber stamps your purchase price and applies a common level ratio. There is nothing that I can do as a lawyer, and any lawyer who is telling you that they can save you money is making a misrepresentation. I think that the lawyers, and there are 2 particular law firms, I'm not going to mention names, because they've been shared with me by property owners who, even after the fact, were told, instead of your purchase price being your assessment, I got it reduced, your $100,000 purchase, to $87,500. Of course, that's not ethical, but that's what lawyers in this so-called business of representing property owners are doing. And what we need to do is always be forthright. Piggybacking what Megan had to say, when you are dealing as an attorney with an adverse party unrepresented, your ethics have to be at their highest. Likewise, if you are dealing with a property owner, you should learn the process, know what the law is, and be well informed in order to answer questions or make a presentation.
John makes an excellent point. We don't charge a contingent fee when a school district appeal for the same reason. The one thing we do tell the people, though, is that it is possible to lower your assessment below the common level ratio if you found some problems on your property that you were not aware of until you moved in. And if you had an inspection report, I tell them, mail me the inspection report, and you read the inspection report, and then you tell me what occurred that was not in the inspection report. And you'd be surprised. There were a number of things that happened. I didn't know my roof was in bad shape, or I had a leak. They said the roof was okay, and now my roof is leaking. That's a defect that you discovered after you bought the property. Had you known about that ahead of time, you might have paid $10,000 less. So there are some issues that occurred, and the people that bought their house without an inspection report, whatever you've discovered afterwards, is certainly something you did not know ahead of time. So that's something else to be aware of next year when you're filing your assessment appeal. Mike?
Yeah, Bob, in the 1990s, I was vice chairman of the Board of Property Assessment Appeals and Review. There were 7 of us. We heard 10,000 appeals a year, 7 people. We would finish the work in 3-4 months. in 2000, Mr. Roddy and the new county council under home rule decided to bring in a board that is part-time. They come in 2 days a month and certify the assessment role, supposedly. Recommendations from hearing officers who are not properly trained, in my opinion, and something has to change there. I've been talking to county council members about possible changes where we go back to where it was, where you had 7 board members hear all the appeals, and they worked nonstop until all the appeals were done. We sent, in the 90s, the appeals board sent out dispositions, the results of the hearing, in 2-3 weeks. Now it's 2-3 months is the norm. We are at the end of the year. There are still 1,000 or 2,000 more appeals that haven't been heard. This appeals board, without even taking a vote, just pulled the plug on appeals for an entire month. And Mr. Silvestri had to sue them to get them back to work. Thanksgiving week, they took the whole week off. And again, once this is resolved with the common level ratio for the 1 year, I don't have a lot of confidence in this board getting the results out to the public ASAP. I hope I'm wrong, but I'm talking to the county council about abolishing this board. And, you know, I know a lot of the people on there. I like them, but this isn't about like, it's about doing the right thing. And the fact that this board is just playing rope-a-dope with the entire process, here we are. And again, county council, what Megan said earlier about having a perspective system, I agree 100%. Dave Montgomery of the board, back in 2010, we were arguing for, well, the county executives have always said the last 20 years, we want to be like the other counties. We don't want to have a reassessment. They don't reassess, so we're not going. But, you know, 66 other counties have an appeals deadline the year before you pay taxes on the appeal. And many of those appeals are resolved before you pay taxes. See, that's just one issue. But as far as just going back to what we talked about appealing every year, Megan, that's great. Bob, it's a great idea. I talked to a woman last week from Brentwood who did that. Last year in 2021, her assessment was jacked up to 87.5% of her 2020 sale price. She bought the house 2 years ago, 87.5%. She took another bite of the apple and she went in this year. And the appeals board shot her down. I asked for the hearing officer notes, which we should all do because you want to see what these hearing officers are thinking. All right. The hearing officer said, well, the property hasn't sold since 2020. No change. We're not giving the 63. We're not even giving the 81. It's a no change. So the Board of Property Assessment Appeals and Review is sending out the no changes. That's the easiest part. Most of them, from what I've seen, are property owners. Property owners.
Same for schools.
Okay.
Same for schools.
Well, I said most of what I've seen. And that's the easy part. No change is a no change. But I predict, I'm going to just, what we did, John, in our lawsuit, I predict that the work product of Allegheny County assessors that came up with a common level ratio of 63.53 for this year will prevail. And if I'm right, we asked Real Stats, one of the local companies who looks at property appreciation in Allegheny County. And last year, the property appreciation was 11% countywide. We have people crunching the numbers right now, John, and we came up with a common level ratio of around 57%. So that is a preview of coming attractions. We're not, just because STEB certified the 63.6, the only reason the county came up with a lower number is because of the lawsuit. You know, they did fix some of the problems. that John addressed in his lawsuit. And all of the taxing bodies knew in June of 2021 that we were filing this lawsuit. And hey, if we were right, that common level ratio was going to drop. Bottom line, if property values go up, common level ratio goes down. That's where we are. But I have it on the board behind me. This is one of the proposals I've given the county council. It may not go through, but if they create a new Board of Property Assessment and Appeals and Review, where you have 7 board members hearing the appeals, they're not making recommendations to a part-time board member. Maybe that's something we should look at to fix part of the problem. That's all.
In the 4 minutes that we have left, John and Megan, why don't you tell everybody what the status of the lawsuit is right now and where it is?
So the bulk of this is actually being handled by outside counsel for PPS. It is on appeal to the Commonwealth Court. It's our position that there is an automatic stay or supersedious that is then associated with that in the order that it is tied to. I believe that there have been some pro se interveners who have kind of jumped in. Just one, okay, I saw that in passing. I'm not aware of a briefing schedule or the media or an order for the mediation for a date for the mediation process, because I believe Commonwealth Court does have a mandate or has a voluntary mediation program.
It's not voluntary.
It's not voluntary. All right, so a compulsory selected. All right. All right. Well, I will turn to the much more knowledgeable Mr. Silvestri, Attorney Silvestri.
Everything that Megan said was accurate. There are several applications for relief that are pending. One is to either quash the appeal or to limit the issues on appeal. So that's the status of the lawsuit. What I'd like to spend a minute doing is where do we go next? And I credit David Montgomery with this because when I requested a late appeal for 2 clients and the Board of Assessment denied it, he cited a case which I legal researched. And what I learned is that if evidence is fraudulent and used in order to get a judgment, and in the Board of Assessment case, a disposition, then as soon as you know that the evidence is fraudulent, if you make a timely application, you can have it voided. So if any of you want to read cases, I have cites for you. 890 A2nd 1078 Commonwealth versus Harper. You can open up a judgment anytime when you discover that the evidence is fraudulent. Great American Credit versus Thomas Mini Markets. 326 A2nd 517. It discusses the inherent powers of the court in order to open up a judgment that was obtained by fraud. There's Hazel Atlas Company versus Hartford. That's a United States Supreme Court. 64 Supreme Court 997. 322 US 238. And I'll just read the quote and be done with it. No fraud is more odious than an attempt to subvert the administration of justice. The court is unanimous in condemning the transaction disclosed by this record. Our problem is how best the wrong should be righted and the wrongdoers pursued. In this case, the wrongdoers are Allegheny County. I've been waiting for the school districts to sit at the same table as I sit at, recognizing the fraud that was perpetrated. As Judge Hertzberg said, the cooking of the books, because the party that should pay for the fraud is the party that committed the fraud, and that's the county of Allegheny. Thank you.
This concludes the seminar. By the way, John Silvestri is a son of a former very prominent common pleas court judge, and your father would be very proud of you, John.
Thank you and happy holidays. Whatever that is for you, yes.
Turn that off.
Okay. Just want to say, I just want to say real quick, thank you for all of you that have attended. If you want Sealy credit, I need your attorney number, and also it's $10 for ACLL members. And if you're a non-member, which we hope you become a member, it's $25 for the hour credit today. The other thing is we will add that list of citations, if that's okay with you, John, as well as the PowerPoint that Mike has put together, and send it out to those who we had the emails for. So thank you so much. Take care. Happy holidays.